Good afternoon, one and all. I am Dr. Prakyat, Senior Resident in Department of Psychiatry, NIMAS, Bengaluru. On behalf of the Forensic Psychiatry Services, Department of Psychiatry, I welcome all the participants who have joined us here for the virtual book release and Forensic Psychiatry CME. Now I invite our head of the Department of Psychiatry, Professor Y.C. Janardhan Reddy sir, who has been heading the OCD clinic for the past 2 decades and has contributed immensely to the field of psychiatry. Sir, I hereby invite you to deliver the welcome address.
Good afternoon. Actually, forensic psychiatry is in some way not very new to me, although I have been involved in OCD clinic for a long time. In fact, when I was senior resident for almost 4 years, me and Suresh, along with Professor Sayas, we took care of the prison wards. And much before that, our director would remember that when she was a senior resident, maybe a consultant to begin with, she did some work on reviewing the criminal files dating back to 1880s. So I have had some association with forensic psychiatry. Of course, Pratima later on specialized in addiction medicine, but continues to have interest in forensic psychiatry. I take this opportunity to welcome our director, Professor Pratima Murthy, who will be delivering inaugural address on the human rights and mental health care in the background of pandemic. Today's program has 2 important components. One is the CME, on the interface of Indian laws on mental health. I think this is a very timely CME because we have moved on from focusing exclusively on forensic aspects of prisoners with mental issues to a whole range of issues, some of which are being discussed today. And we also have a function of release of books. Forensic psychiatry in India, interface of Indian law and mental health book would be of great use to practitioners because forensic psychiatry is not something which is regularly taught in most medical schools who run MD psychiatry programs. And we have an manual on mental care of transient persons in India. And Professor Shekhar Seshadri, an expert in this area, is going to really talk about this. Professor Nandi Mart, if I'm not wrong, was a Suresh guide for his PhD thesis, and he has worked extensively in this area. And Suresh himself is a person who has been associated with forensic psychiatry for a very long time. I take this opportunity again to welcome everyone on behalf of the Department of Psychiatry. I now request our director to start the inaugural.
Thank you, sir, for inviting the speakers and the delegates. It is our esteemed pleasure to have with us Professor Pratima Murthy ma'am, Director, NIMAS, Bengaluru. Ma'am has over 3 decades of experience in the field of mental health. She is an alumnus of Bangalore Medical College. She completed her diploma and MD in psychiatry from NIMAS, Bengaluru, and has diploma in psychological medicine from the University of Manchester, United Kingdom. She has earlier served as the professor and head of Department of Psychiatry at NIMAS, head of the Center for Addiction Medicine, and head of Forensic Psychiatry Services. She is a recipient of the WHO Regional Director's Special Appreciation Award 2021 for promoting tobacco cessation and control, the Rajya Ramanna Award for Excellence in Science from the Government of Karnataka for her outstanding contribution to the field of science, the Marfatya Award, and the Tilak Venkoba Rao Ration Award of the Indian Psychiatric Society. She is the recipient of the Rotary Lifetime Achievement Award in the field of de-addiction in 2020. She has undertaken several consultancies and assignments with the several international organizations like World Health Organization, the United Nations Office on Drugs and Crime, the International Labour Organization, and many more. She is an international consultant to the WHO for the MH gap in mental health and addiction. She has also provided her consultancy to the National Human Rights Commission on quality assurance in mental health. She has been a member of many task forces at the national level and served on several intramural committees of the NIMAS and extramural committees at the national level. Professor Murthy has contributed to public policy in the field of mental health, addiction, and integration of mental illness with non-communicable diseases. Through her work on the human rights of persons with mental illness, she has contributed significantly to mental hospital reforms and the expansion of mental health care in the country. She has also been involved in improving institutional mental health care for women through her work with the National Commission for Women. As the head of the Forensic Psychiatry Services, she has been involved in improving mental health care in prison and other custodial settings. She has been involved in about 40 research projects, guided more than 50 dissertations of postgraduate students in MD, DM, and PhD courses, and has about 250 peer-reviewed publications. Now, I would like to invite our beloved director, Professor Pratima Murthy ma'am, to deliver the inaugural address and to enlighten us about the rights and mental health in the background of pandemic. Over to you, ma'am.
Thank you very much, Prakyat, for that generous introduction. Very good afternoon to everybody. Professor Janardhan Reddy, Head of the Department of Psychiatry, Professor Shekhar Shishadri, Senior Professor of Child and Adolescent Psychiatry at NIMHANS, Professor Nandimat, Professor at the National Law School University, my colleagues from the Forensic Psychiatry team, Dr. Suresh, Dr. Naveen, the rest of the team members. I'm sure there are a lot of esteemed listeners today, and of course, students and others interested in forensic psychiatry. A very warm welcome from me. It's particularly nice to be involved with this program because this is on a topic close to my heart. And as Professor Janardhan Reddy mentioned, we're going to be talking about not just human rights, we're also going to be talking about consumer legislation and the care of patients, challenges the implementation of the Mental Health Care Act, mental health concerns of transgendered persons, and we're going to see the release of a couple of documents on the interface of laws and mental health, as well as a manual for transgendered persons. So I think forensic psychiatry has indeed come a long way since its infancy and its early experiences. And I think from the days we used to go back to the records of the last century, laboriously writing down whatever we saw in those case notes, which I actually find fascinating in their own ways because they really provide a world of information to current issues in both the care of people in institutional settings, in forensic settings, as well as common law. I think there are a lot of issues that have been covered and a lot of ground that needs to be covered. So in that context, I just thought that in the inaugural address, I would talk about human rights and the mentally ill in the background of the pandemic. So what I would do is give you an introduction to human rights, talk of the human rights initiatives in the Indian context, focus a little bit on the extent of mental illness that we have in our country and the limited resources we have to address these. What has been the human rights in the context of the pandemic? What have we done from NIMHANS in terms of mental health care during the pandemic? Other initiatives, for example, from the National Human Rights Commission in terms of advisories of mental health care during the pandemic, and some thinking about what are the ways forward. Human rights are a fundamental right to all human beings, and we know that they include the right to life, of course, to liberty, freedom from any kind of torture and slavery. People have a right to opinion and expression, to work in education, to a safe and clean environment, which is becoming a huge concern now. And in the context of human rights, when you look at mental health and human rights, many of these things are amplified or are a greater need among people with mental illness, particularly the right to treatment, as well as the right to as independent a living as possible, the right to equal opportunities in education, employment, and without any discrimination or threat of any kind. In the context of the human rights, we can see that there have been several attempts for almost now, more than 1.5 centuries, or looking at the treatment of persons with mental health care, or with mental illness. Right from the Bengal inquiry to the investigations, of the way lunatics, as they were called at that time, were treated in various asylums in the 1800s, you'll see that a lot of concern has been on institutional care of persons with mental illness. And of course, that used to be severe mental illness. You'll see the reports in the early 20th century from both Mapother and Moore-Taylor, who actually rated mental hospitals on a scale of badness rather than a scale of goodness. And so many kind of problems were encountered in those reports of the 1900s. We know with the Moore and the Mudaliar committees that a focus on postgraduate education, increasing human resources in healthcare, as also in mental health care, saw the beginnings of psychiatric postgraduate training, including the setting up of our postgraduate programs in psychiatry and psychology in the 1950s. There were a series of medical superintendent workshops that actually, again, talked of the difficult conditions for patients in mental hospitals, their attempts with very limited resources to try and improve care. And this has been a constant theme. In the 1990s, NIMHANS, with the support of the National Human Rights Commission, initiated the first quality assurance project in mental health. At that time, that was the team led by Professor S.M. Channabaspanna, and Justice Mallimath from the NHRC supported this initiative. And that included a report of the kind of situation in many mental hospitals, actual visits to hospitals, both in the public sector as well as some of the private healthcare institutions. And that was a real eye-opener on the fact that whatever Moore Taylor and Makota had reported in the 1930s and 1940s continued to be a problem in several of the mental hospitals. The salient feature that all of us remember was a significant amount of overcrowding, the lack of adequate amount given in diet, lights being switched off very early as dinner being served at 6 o'clock in the evening, problems of water, electricity, problems of inadequate toilets, inadequate clothing, compulsory uniforms, lack of dignity to patients. I can go on for a whole hour about the problems that were there. Equally, there were attempts that were made by concerned superintendents to try and improve the quality of diet, to make the patients more comfortable and so on. There were very few hospitals which had adequate rehabilitation facilities. Most of the admissions there were involuntary admissions, and there was no follow-up and aftercare, and specialized services were present only in the very few hospitals. Now, I always say that this very, very important report would possibly have gone into the dustbin of history had it not been for the Erwadi tragedy, which actually the commemoration of the anniversary occurred just about a week ago. And the Erwadi tragedy, unfortunate as it was, really brought into light the human rights violations that persons with mental illness go through. And this report of the National Human Rights Commission came into the limelight. The Supreme Court took notice of these situations and made sure that there were more rapporteurs going to the various mental hospitals, negotiating with different state governments and trying to improve the quality of care in the mental health institutions. Budgets improved, infrastructure improved, the attention to various aspects like diet, like voluntary admissions, all of it improved. And we actually saw that hospitals that were monitored directly by the NHRC and through its rapporteurs actually made a lot more progress. So while there were progress in some areas, there was also a continuing problem that continues in many areas. And one of the things that we have suggested to the Ministry of Health and Family Welfare is just like NIMHANS kind of opened up in terms of postgraduate training, getting younger people in, if all the mental hospitals could be encouraged to start postgraduate programs so that an academic atmosphere allowing people from outside is supported, the likelihood of transformation of these institutions is much likely to be occurring at a much higher speed and pace. So that is where we hope that mental health institutions will go to. We know that we should not focus mental health care only within institutions, that we need to go beyond institutions, but they will continue to remain as one of the pillars of treatment for people with severe mental illness, particularly when they need more intensive care. But what happened as a consequence, not only of this, but also the National Mental Health Program, which had been, again, prior to that, almost 30, 40 years, it hadn't really taken off. It gradually expanded over time, again in the 1990s. And now, with the National Mental Health Program, there came the District Mental Health Program. The National Mental Health Policy, which was formulated in 2014, looks at moving into community care for the mentally ill. And this makes the District Mental Health Program the focus in each state around which services need to be developed. And we now know that more than 650 districts have embraced the National Mental Health or the District Mental Health Program. But of course, the quality of care across the districts is extremely variable. There have been some outstanding district mental health programs that have taken a lot of steps to make sure that people are more people are seen, medicines are available, some degree of psychosocial care is provided by a multidisciplinary team. The example of Karnataka is indeed outstanding in this area, where Super Tuesdays to look at people with mental illness, an attempt to look at the mental health program at the taluka level, using telemedicine to reach out to more people. This has been quite a model program, and several other states have also now gone on board to look at this program. And we also have the Rights of Persons with Disabilities Act, which was enacted in compliance with the UNCRPD. And this again has focused on protecting the rights of persons with all disabilities and including mental illness as one of the disabilities, and to try and have a non-discriminatory attitude. We know that the Mental Health Care Act 2017 replaced the earlier Act of 1987, but really the earlier Act had never kind of materialized in terms of all the various components of the Act that were present. So we hope that the Mental Health Care Act, in addition to looking at the rights of persons with mental illness, will ensure proper treatment, proper care of persons with mental illness. Again, it is slow in terms of the various states developing and adopting the rules. There's a long, miles ahead to go to make sure that the mental health care is enacted both in letter and in spirit. But certainly it's kind of brought into focus the several aspects of assuring human rights of persons with mental illness. Now we have a huge burden, and we know that 1 in 7 Indians perhaps has a mental health care problem. We know that the treatment gap is upward of 75% for all kinds of mental illness, both severe mental illness as well as common mental disorder. The COVID-19 pandemic has perhaps amplified the problems that occurred in terms of the lack of mental health care services and the impact of disasters and various other kinds of stress in terms of impact on psychology. We certainly know that we have a woefully inadequate mental health workforce in our country in terms of specialized personnel. Although, as far as psychiatrists are concerned, there is a slight increase in the ratios in terms of the population. It's still few and far between. So we know that when it comes to mental health care, we have to have a spectrum of services. We have to involve players from general health care to also provide mental health care services. We should not just look at tertiary institutions. We should look at different levels of primary and secondary health care as well. We need to look at solo practitioners providing services, teams providing services. We need to look at services in institutional settings. And what's more importantly, we need to look at how services can be provided as close to people in as unstigmatizing a manner, so that finally mental health care reaches everybody who needs it. So, not only is the right to health an important fundamental human right, there are several documents, including the High Commission of Human Rights on the importance of mental health care. There are several covenants which look at the mental health care of adults as well as children, as well as the persons with various kinds of disabilities. And it's important to have this in the entire framework of mental health care. It's said that COVID-19 has really got us to rethink more than ever how we need to make the mental health care framework in the broader framework of human rights, including in psychiatric institutions. And I think that's a very good point that that brings into focus that we need to provide proper mental health care to people, both with severe mental illness as well as with the milder forms of mental illness. During COVID, there certainly have been several reports of new onset psychiatric symptoms, exacerbation of symptoms in people with mental illness, increase in suicide rates, increase in substance use, and of course, challenges in accessing mental health care. And one of the key messages from the Lancet Commission is that mental health care problems lie along a continuum from mild distress to severe mental health conditions. There are people who might have been previously resilient, who, because of the severe amount of distress during the COVID, have had higher experiences of anxiety, distress, and there are people with pre-existing mental illnesses who might have had an increased intensity of their symptoms. And all this needs to be kept in in one's viewpoint when one looks at providing mental health services to various kinds of people, both with pre-existing mental health problems, people from a low-income background who may have a difficulty in accessing services, various minorities who might be at greater risk for self-harm and worsening mental health. And of course, we now know the immense impact COVID-19 has had on healthcare workers and their own mental health. And of course, if people don't care of their own mental health, it's very unlikely that they will be able to take care of others' mental health. NIMHANS has been in the forefront of several programs we've conducted during the COVID pandemic. Historically also, we've been looking at sustainable models. We've been looking at policy recommendations backed by evidence. We've been cited as a model psychiatric center by the apex court in the country. We've collaborated with the Human Rights Commission for several decades now. And our findings have become a benchmark for the care of people in psychiatric institutions. We have also spearheaded the movement into community care, as you know, in the last 3 or 4 decades. And we've been involved in the re-strategizing and the expanding of the National Mental Health Program. Of course, there's a whole series of resources that we've brought out. Several of our departments have all been involved in bringing out awareness material, telecounseling, modules for training of various groups of people. So there are several details which is available on our NIMHANS website, which you should take a look at. It's not just NIMHANS. I mean, NIMHANS is one of the partners which has been working with several other people, with other institutions. The Ministry of Health and Family Welfare has also released a lot of material in terms of mental health care. We have a psychosocial helpline to help people during the disaster, which has got upward of 5 lakh calls. And we now have calls specifically routed for children, for women, for senior citizens, so that each of these groups can get the mental health care from wherever they are. I must mention that the National Human Rights Commission has also, provided an advisory in the context of the COVID-19 pandemic, recognizing that there can be a lot of violations of human rights, particularly during the pandemic. We quickly look at the various aspects of the advisory, which talks about setting up of health lines, making sure caregivers' health is taken care of, the 3 A's of accessibility, affordability, and availability of mental health care services, improving telehealth services, and of course, making sure that people with mental illness are provided care in the outpatients. Homeless people with mental illnesses are taken care of in a non-discriminatory manner, with access to treatment, with quality assurance ensured whenever patients are being seen, the right to inpatient care, as well as to look at health insurance, which is again something that hasn't kind of developed very well. They've also advised on how COVID treatment care facilities should provide comprehensive care, should be properly supervised to avoid any abuses, should have adequate activity so that people don't feel isolated and depressed. And of course, as with all human rights commissions, a right to protection from cruel, human, and degrading treatment and good living conditions. The advisory also talks about the importance of confidentiality, as well as the need for promotion of mental health through preventive programs in the community, particularly in the context of the COVID. Next slide, please. Yeah. Then, of course, grievances. Grievances can be very common, and it's very important to take on board any complaints that might be received, strengthen telephonic counseling, district mental health programs, try and set up mobile mental health units, as well as the provision of psychological first aid. Training of various kinds of personnel, especially the frontline personnel like police personnel, healthcare personnel, post-COVID management, considering the recognizing increasingly the mental health aspects of long COVID, and of course, research in the area is something from a human rights perspective also that has been recommended. And finally, the recommendations of the Human Rights Council also talks about a paradigm shift which protects the rights, autonomy, and preference of people with mental illness on an equal basis. Several other initiatives by the UN talk about improving access and quality of mental health care delivery, creating possible environments that are conducive to the realization of human rights, preventing coercion, and reducing stigma and discrimination. I will end with some thoughts on the way forward. We need to look at expansion of the National Mental Health Program, setting up a continuum of services in the community, making sure that our policies are dynamic and responsive, focusing also on providing insurance for people with chronic mental illnesses, training programs to create awareness on the rights of persons with mental illness. I also want to emphasize that we would be looking and working with government to see, again, if the mental hospitals that are there in the country can be much more open, can have more younger people and a more academic environment, which would definitely improve the engagement of young people who might be listening to this program to get involved in mental health care, treatment, interventions, and policies, so that we have a wide group of spokespersons for the rights of persons with mental illness. It's important to think of human rights as something close to all of us, as something very simple in terms of justice, in terms of equal opportunity and dignity without discrimination. And that's something very, very important that we need to look for as concerned citizens to make sure that people with mental illness get a better deal and get a fairly equitable access to all the rights that everybody else enjoys. I'd just like to thank Dr. Bhavika and the forensic psychiatry team for having me here. I still feel very much a part of the team, given that my interests lie here. Thank you very much. And I'm sure the rest of the program, looking at so many other different aspects, will also throw a lot of light on mental health care issues. Thank you very much.
Thank you, ma'am, for that wonderful presentation on human rights and mental health. Your insight into the human rights and mental health in the past and during times of COVID and how it is impacting the lives of so many people was both fascinating and disturbing at the same time. But we particularly like the hearing about the initiatives in the past and presently in this testing time, ma'am. Thank you. Thank you again, ma'am. We proceed towards the book release program. We are delighted to bring out the first book titled Forensic Psychiatry in India, Interface of Indian Laws and Mental Health. This book aims to familiarize the psychiatry resident as well as practicing psychiatrists with the complex interface between psychiatry and law. Now I request our beloved director, head of the Department of Psychiatry, resource persons, and all the delegates to join us for the book release. Thank you, ma'am. The second book is titled Manual on Mental Health Care of Transgender Persons in India. This book aims to help psychiatrists meet the unique challenges of transgender persons in the background of new law, Transgender Persons Act 2019. I request the director, the head of the Department of Psychiatry, resource persons, and other delegates to release the book. I would like to place on record on behalf of the editors of the books to express our sincere appreciation to all those who generously helped to make these books a reality. We would like to express our gratitude to the reviewers of the Manual on Mental Health Care of Transgender Person in India, Dr. Avinash D'Souza, Consultant Psychiatrist, Lokmanya Tilak Municipal College, Mumbai, Dr. Darpan Kaur, Associate Professor of Psychiatry, Mahatma Gandhi Mission Medical College, Maharashtra, and Dr. Prasad Raj Dandekar, Head of Radiation Oncology, Reliance Foundation Hospital, for their critical review of the manual. Would like to thank Dr. Chetan, Assistant Professor of Psychiatry at NIMHAS, for coordinating the video modules, which has contributed immensely in bringing out these books. We would also like to thank Indian Psychiatric Society for their support. Thank you all. It's a great honor to introduce our next speaker, Professor Shekhar P. Seshadri, sir. Sir is a child psychiatrist with 10 years of experience in the field of child mental health, but his work extends beyond the clinical population, amongst others, to children in institutions, educational spaces, and in the context of law across the country as well as the South Asia region. With a view to enabling access to mental health care for the most vulnerable child population, his special areas of interest in child mental health are childhood trauma, gender and sexuality, and life skill education. An artist and musician, he uses a number of creative methodologies in child mental health interventions, including theater in development approaches. In the belief that wider psychosocial interventions are rooted in child rights, in addition to his preventive, promotive, and curative child health interventions, he has undertaken various legal and policy-related initiatives. He was a part of the national deliberations on the POCSO Act 2019 during its drafting, and more recently, an active part of the debates around the December 2017 Juvenile Justice Act on children in conflicts with law. He has also engaged extensively as member of working groups of the National Commission for Protection of Rights of the Children on issues such as substance abuse and elimination of corporal punishment in school. Finally, all his policies and practice work find their way into training and capacity building program for target audience ranging from students of mental health disciplines and mental health professionals in clinical setting to childcare service providers in non-clinical settings, including community health workers, teachers, government and non-governmental staff, counselors, and judicial personnel. Sir, I hereby invite you to enlighten us about the rights of transgendered persons.
Thank you very much, Prakyat, and thank you, the entire team, for this invitation. I want to locate what I want to share with you on rights in the context of transdisciplinarity. In India, disciplinary boundaries have been generally difficult to bridge, be it law or medicine. Professionals in each field tend to work within their sector without necessarily collaborating across sectors. An example of intersectoral collaboration emerged particularly in the context of the impetus to decriminalize homosexuality. The criminalization of homosexuality had become a tool of harassment and violence against the LGBTQI+ community, hampering public discussions on homosexuality and contributing to discriminatory attitudes. So the genesis, friends, of this intersectoral collaboration in the context can be traced to a seminar organized at the National Law School of India University in Bangalore in September of 1997. Now, exemplary activist work had been done in other parts of India, but this was the first collaboration between lawyers, activists, mental health professionals, as well as artists to begin work towards removing the law. And this proved as a significant starting point for continued conversations across disciplines with a view to improving the status of LGBTQI persons in Indian society. The reason this is important in the context of rights is there has been significant process in specialized sectors like NGOs, informal support spaces, legal initiatives, and individuals who were helped by individual doctors. However, as the movement progressed, the sparks were many, but the interventions were still fragmented. So the first point in rights is an integration of services rather than in fact fragmentation, and an unsynchronized way of actually assisting transgender persons. Second issue of rights is the absence of a protocol-driven initiative and institutionalized responses or established intersectoral collaborations that work synergistically to provide the most effective form of intervention to people in need. So 2 points here on rights. One is intersectoral collaboration, which is protocol-driven. And the other is essentially that the interventions that they require should not be fragmented. From a mental health perspective, the reason why this is important is that if you really look at the prevalence of certain morbidities, substance use disorders, depression, suicidal behaviors in the TG community, and the rates therein, and the fact that if a person has to go to one hospital to see an endocrinologist, another hospital to see a mental health professional, a third hospital to see a surgeon, with all the kind of stigma that prevails, this becomes a rights-related issue. As the momentum gathered, the intersectoral collaboration improved, and the movement against Section 377 of IPC it achieved a degree of success, if you remember, with the Delhi High Court judgment, which decriminalized consenting homosexual relationships between adults. Then, of course, there were a whole lot of petitions. And it was at this point of time that lawyers and medical fraternity and mental health professionals collaborated to draft a persuasive scientific affidavit which would place proven medical facts before the court. And this is important to keep in mind. Now, here's the interesting thing, that when the Nalsa versus Union of India issue came about with Justice Radhakrishnan and Justice Sikri on the bench, now what were the key facts, friends? See, the case was filed by the National Legal Services Authority to legally recognize persons who fall outside the male-female gender binary, including persons who identify as the third gender. So please note this issue of the binary and the non-binary and the cisgender and the transgender terminologies. The issues and decisions that the court had to decide on was whether persons who fall outside the male-female gender binary can be legally recognized as a third gender person. The court deliberated on whether disregarding non-binary gender identities is a breach of fundamental rights guaranteed by the Constitution of India. It referred to an expert committee on issues relating to transgender. This was constituted under the Ministry of Social Justice and Empowerment. But this was a landmark decision, friends, where the apex court legally recognized the transgender person for the first time and discussed gender identity at length. The court recognized that third gender persons were entitled to fundamental rights under the Constitution and under international law. Further, it directed state governments to develop mechanisms to realize the rights of the third gender and transgender person. But how did the court define the transgendered person? And this is very interesting. The court upheld that the right of all persons to self-identify, self-determination, that's a key right here. And it declared, for example, if you look at the Hijra community, they can legally identify the third gender. And the court said that gender identity did not refer to biological characteristics, but referred to an innate perception of one's gender. Thus, it held that no third gender person should be subjected to any medical examination, any biological test which would invade their right to privacy. And this brings us to the whole issue of fundamental rights. The Supreme Court interpreted dignity under Article 21 of the Constitution to include diversity in self-expression, which allows a person to lead a dignified life. It placed gender identity within the framework of the fundamental right to dignity. Article 14 on equality and freedom of expression, which is Article 19, framed in gender-neutral terms all persons. Consequently, the right to equality and freedom of expression would extend to transgender persons, because it drew attention to the fact that transgender persons were subject to extreme discrimination in all spheres of society, which is a violation of their rights to equality. And further, it decided the right to express one's gender through dress, words, action, and behavior under the ambit of freedom of expression. Rights. Under Article 15 and 16, discrimination on the ground of sex is explicitly prohibited. The court held that sex here does not only refer to biological attributes such as chromosomes, genitalia, secondary characters, but also includes gender based on self-perception. So it held that discrimination on the grounds of sex included discrimination on the basis of gender identity. This, friends, is called the Yogyakarta Principle to recognize transgender persons' human rights. And the court directed that public awareness programs should be held to tackle stigma. It directed the state government to make provisions for legal recognition, recognizing the third gender persons as socially and educationally backward, and for reservation, and taking steps to frame the social welfare schemes for the community. So this was a landmark decision because it is the first to legally recognize non-binary gender identities and uphold the fundamental rights of transgender persons in India. But the matter became curious. The Transgender Persons Protection of Rights Bill was introduced in 2019 in the Lok Sabha by the then Minister for Social Justice and Empowerment, Mr. Tawarchand Gehlot, who incidentally is the governor of Karnataka now. And the 2018 bill, of course, invited a lot of 2014 order in the Nalsa versus Union of India. In fact, they say that the critics allege that the provision establishing the district screening committees left gaps for incompetence and prejudice. So following protests by the queer community against the 2016 and 2018 bills, the 2019 Act has done away with few of the very severely criticized provisions of the 2018 bill, such as criminalization of begging and the establishment of district screening committees to process applications for issuing of PG certificates. But it fails to incorporate other principles in line with the Supreme Court judgment, such as the right for self-determination without undergoing SRS and reservation in jobs and so on. The Act has been criticized for imposing less punishment for crimes against transgender people compared with punishment for crimes against cisgender people. So actually on 27th of January last year, the Supreme Court issued a notice to the central government in a petition challenging the constitutionality of the Act. So many of the TG people say, talk about the day of the passing as a black day or as a gender justice murder day, and that it is draconian and so far. This brings me to the issue, what about a child then? A child who has gender dysphoria, a child who goes through assessment and is found to have gender identity issues. We were requested in Samvad, which is a national initiative and an integrated resource for child protection, mental health, and psychosocial care. And I'm taking the liberty, friends, to put on chat some of our links because we were asked to write a policy paper aiming to lay out the specific psychosocial and mental health vulnerabilities of transgender children, with specific emphasis on the problems they face at home and within families due to stigma and discrimination, due to lack of awareness and sensitization of the general public on issues of alternative sexuality. The consequent risks of runaway behavior, trafficking, abuse, mental health problems, dysphoria, depression, and related issues, and the lack of sensitivity of child protection functionaries and the dilemma of placement when such children come to the state care and protection systems. The experiences of these children, friends, when they are placed in existing girls' or boys' home, that is of discrimination, bullying, and abuse, is concerning. And the intention of this paper was to build a case for separate state-run childcare institutions, including training of childcare staff for the care and protection of this vulnerable subgroup of children. So if you look at the child community and the student community and what rights mean, on the one hand, the right to dignity, to self-determination, to self-expression, how you dress, and the right to integrated, intersectoral, protocol-driven interventions. And I'll come to that in closing when I speak about SRS protocols. But on the subject of students and children, it would surprise you to know, a little over a month after Oxford English Dictionary announced that it would include gender-neutral honorifics, MX, instead of Mrs. or Mr. or Miss or MS in its next edition, Nalsar University of Law, Hyderabad, has used the honorific in a graduation certificate for a student who didn't want to be identified by gender. So MX, which is pronounced mix, presents a viable option to both transgender persons as well as those who don't want to be identified by gender. The decision was taken by the Hyderabad-based institute after the student requested the administration to change the title in the transcript. Some publications got in touch with the student and said that getting this change was quite effortless. I quote, "I asked the Nalsar administration to use MX because I did not see any reason why my transcript or academic records needs to carry markers of my gender identity, especially given that I'm still uncertain as to how I wish to be identified," the student said. Interesting, isn't it? How the issue of rights can come to an issue as simple as self-expression and self-identification. And the truth is, even in the TG community, the male to female and female to male, which is a binary lens, we know there are hundreds of shades of people who may not necessarily undergo medical interventions or SRS for that matter. Let me conclude, friends, therefore, by saying that what rights for transgender people mean is that individuals in the health sector who are thus far working on the basis of personal conviction need to do more training programs for colleagues and students, as a result of which health-driven protocols should become institutionalized. And this was always the reason why I started working in this area at a time no one addressed it. And I cannot tell you how delighted I am that Suresh and his team and his colleagues have really institutionalized this in a manner which is culminating today in the books that you have released. The hope is that irrespective of where a person goes, for instance, for certification of SRS procedures, international standards and protocols of assessment should be followed and legally accepted documentation to be provided. This capacity should reside in the institution and not in any individual. In the context of SRS, it is also important for all the health professionals, psychiatrists, endocrinologists, surgeons, gynecologists, and others. We need to be networked. When we network, we address their rights in a manner that the benefit to the individual seeking help is not fragmented. Now, in the past, an individual had to run around to seek these services on his own or her own. The emerging need now is to consolidate all these services in a one-stop place within the same institution, so that either a general hospital or through a nodal person to coordinate between different players. Now, we know some states are already providing subsidies for many of these medical processes and procedures. Tamil Nadu is one such example. But my appeal to you today in this CME and the book release is that it's important for all of us as players involved in such intersectoral collaborations to understand the triangulation between medical systems, processes and responses on the one hand, pathologizing, depathologizing of sexual orientation and gender identity, and law, procedural human rights for central, coherent, and synergistic interventions. Today's function, friend, is a true example of the start of the discourse on this central point. Thank you very much.
Thank you, sir. That was very insightful. I'm sure many of us got a better perspective of this sensitive topic after hearing to you, and we'll be able to be more inclusive in our day-to-day practice and be more sensible in using these sensitive terminologies in our practice of psychiatry. Thank you again, sir. Kindly note that the books which have been released now will be circulated to all the delegates by tonight. Now, I would like to introduce Professor Ovid Nandimat, sir, to speak about doctor-patient relationship in the era of Consumer Protection Act. This is a subject we are deeply concerned, considering how the doctor-patient relationship has evolved over time to a consumer and service provider-based model. Dr. Ovid Nandimat, sir, is a professor of law at National Law School of India University, Bengaluru, and chair of HAL Defense Public Sector Undertakings Business Laws. He has been a visiting scholar at Bradford University, visiting faculty at Warwick University and Cardiff University, United Kingdom. He is also Fulbright Fellow and Stegner Fellow to the University of Utah. One of his areas of specialization include medical law, and he is the program coordinator for the postgraduate diploma in medical law and ethics provided by the Distant Education Department, NLSIU. He is also the executive chair professor in charge of the think tank of health at the National Law School. He has been a teacher for many of us here at NIMANS and an inspiration for many of us to take PGDMLE. He is an institution by himself and has played many crucial roles in drafting health laws. I welcome you, sir, and now invite you to speak on this important topic of doctor-patient relationship in the era of Consumer Protection Act.
See, I am actually sharing my slides. I don't know whether they are visible.
Sir, it's visible, sir.
Okay, thank you very much for that confirmation. That helps. So I have been given a very simple task, unlike my other colleagues who spoke before me and who are likely to speak after me. See, I have been asked to really unfold the new consumer legislation which has come into force. This is no news at all because all of you, especially doctors, are speculating whether they fall into the ambit of Consumer Protection Act, that is the new law, or not. So, I wanted to really start by saying, when this particular new bill was put into the parliament for its consideration, Sri Ramvilas Paswan, who was the then minister in charge of consumer affairs, said, the act will prove a significant tool in protecting consumer rights in the country. So this is what he said. So what I would like to really say at the very outset is, before we actually understand how this law repercutes on the medical, fraternity, we need to understand one thing very clearly. This law is basically meant to do consumer welfare. The whole focus is upon consumer welfare rather than how it impacts one or the other professions, etc. So in the light of that, I would like to, actually take you through my presentation. And if you really look at the Consumer Protection Act machinery, it remains quite same like the earlier law itself. You have consumer protection councils. We call it as a federal structure because at district level, you have district consumer protection council. At state level, you have state consumer protection council, and you have central consumer protection council working at the national level. These are the bodies who act as, watchdogs. They act as policy reforming agencies, and they try to provide advisory to executives to bring further reforms into both policy as well as law. And as far as concerned, again, we have a federal structure there. You have District Consumer Commission, which was earlier called as Consumer Fora, District Consumer Fora, and you have State Commission and National Commission as well. But there is one brand new institution which has come into picture. We call it as Central Consumer Protection Authority, or CCPA. This was not there earlier. And this is probably going to intervene because CCPA, or Central Consumer Protection Authority, is headed by Chief Commissioner and such number of commissioners who are going to be appointed. And they would be assisted by Director General, who has the authority to investigate into the matter. And there would be investigative wing and additional DS, DGS, etc. are also going to be. There is going to be complete paraphernalia, which would work under, the Chief Commissioner or Chief Commissioner of Central Consumer Protection Authority. But the first question first. Even to this date, many doctors do, ask me, they call and ask me whether new Consumer Protection Act 2019 exempts them, whether it is applicable to them or not. Let me say at the very outset two things. If you ask me personally whether professional services should be brought under the ambit of Consumer Protection Act, my take or my vote or my answer is very clear. Ladies and gentlemen, I am of the opinion you cannot bring any professional services under the ambit of consumer protection law. But any which ways, my opinion doesn't matter at all. Because when this question was raised or when this question was asked, the question was answered in one of the earlier judgments, to which I will come to, by the Supreme Court saying that doctors do come under the ambit of Consumer Protection Act. That is how they were, tried in consumer so-called courts. And the same system, even to this date, continues. But I'm sure many of you might have little difficulty in digesting whatever I'm saying, because the speculation that doctors do not come under the ambit of Consumer Protection Act still continues. So I try to really put it pretty much in a logical way. There is a school, even to this date, believe the new law exempt doctors. How do they try to extend their logic? How do they try to defend themselves when they take a claim that this law is not applicable to them? They actually try to compare the draft bill and final version of the law. And they say in the draft bill, there was mention of, health services, which is been omitted now in the final version. And that omission they are trying to take as a conclusive proof to say that doctors do not fall under the ambit of consumer protection law, which I would tell you as a lawyer is not a correct way of reading. Number two, the Honorable Minister's introductory speech in Rajya Sabha. See, while introducing this bill in Rajya Sabha, Shri Ram Vilas Paswan ji in Hindi said, I'm not translating, but I'm just paraphrasing what he said. He said there was a demand that the health services should be dropped, and we have eliminated health service expression from the definition. This is what he said. And this is being taken by the doctor friends and to some extent my lawyer friends as well, to conclude doctors are eliminated, which according to me is again a very wrong interpretation, because it is not the minister's opinion which should matter. It is ultimately the parliament which has passed the statute, and we have to really find out the parliament's intent. And literally, if you interpret subsection 42, section 2, subsection 42 of section 2 of Consumer Protection Act, which defines services, I would refer to that in a while's time. People do say, oh, medical services are not explicitly being stated therein. That is why this law is not applicable to us. And finally, I will not try to waste your time. Reading the law disjointly and rationalization of personal belief, because many doctors do hope that this law should not haunt them. And they find it a very convenient approach to say, look, this new law is not applicable to them. But if you really come to the second school of thought, to which I belong, we really look at the purpose and purposive interpretation of Consumer Protection Act. And we read law comprehensively and try to read the law in its context. And we try to adhere to or recourse to unbiased rationalization. To make my point little simpler, let me just run you through subsection 42 of section 2. Subsection 42 says, service means service of any description which is made available to potential users and includes but not limited to the provision of facilities in connection with banking, financing, insurance, transport, processing, supply of electrical or other energy, telecom, boarding or lodging or both, housing construction, entertainment, amusement, or the purveying of news or other information, but it does not include the rendering of any service free of charge or under the contract of personal service. So if you really read this, there are two very important things which you need to, or I need to call your attention, ladies and gentlemen. One is it says, but not limited to. That means the list, whatever that has been inserted or provided here, is inclusive, or you can say it is illustrative and not exhaustive. And there are explicit exemptions with regard to service free of charge or service under contract of personal service. Except this, if there is a service provisioning, including medical services, as it was decided by VP Shanta's case earlier, you fall within the ambit of Consumer Protection Act. So I want to once again reiterate the precedent of VP Shanta versus IMA is still continuing to be a good law. Many doctors do really argue with me, saying that VP Shanta was interpreting the erstwhile law, and the new law, you cannot extend VP Shanta's argument. For them, the simple answer I always try to give is, look, in the earlier Consumer Protection Act also, the word health services or medical services were not explicitly included. That is why Indian Medical Association went to the Supreme Court by way of petition, and they requested the Supreme Court to clarify the issue, whether doctors fall under the ambit of Consumer Protection Act or not. So to answer their question, after hearing all the parties, Supreme Court came to the conclusion, right or wrong is a different matter. Supreme Court comes to the conclusion that doctors fall within the ambit of Consumer Protection Act, even though there is no specific mention of the word health services or, you can say medical services. So that is why, contextually speaking, VP Shanta law has not become bad in the light of new law coming into force. So it continues. For more information, if you wish, you can refer to my co-authored editorial, which I published few days after this new law was put into force by Gazette notification. The second one is, there are few more risk exposure points in this new law. And before I move any further, I wanted to make it very clear, ladies and gentlemen, that when you are looking at the new law, don't immediately try to relate it to your sphere of work. Oh, I'm a doctor, I have been further pushed to a bad state here, etc. You need to understand the whole consumer protection law has in its ambit or has its objective of doing consumer welfare. That is why we are trying to make the way for consumer to, find justice for himself. In this effort of ours, doctors are probably being exposed little more for fewer more risks. What are they? First one is no fee for value of services paid up to 5 lakhs. Imagine if I am paying less than or up to 5 lakhs of fees. That is, in one sense, in your context, I can say, if I am paying 5 lakh of rupees or less than hospital fees, and if I wanted to litigate against the doctor in a consumer court, there is no court fee, or sorry, no court fee is a wrong word, no fee I am supposed to pay. And even after 5 lakhs, I need to pay very little marginal amount of a fee. It is not equivalent to court fee, which almost works out to 10%, somewhere around 10% of the total amount of relief you are seeking. So this eases the way for the consumer further. The second one is provision for e-filing of complaints and video conferencing for hearing. This is again one more very liberal step where they have said, instead of asking the consumer to petition in a technical format, they have said, sitting in the comfort of his home, he can, do an e-filing and seek for video conferencing for the hearing, and he can litigate against the service provider. This is going to be, according to my hunch, it is going to be the game changer, because the consumer is encouraged to litigate more in one sense. If he feels he has got a bad deal, sitting in the comforts of your home without moving out of his home, he can try to litigate and seek justice for himself. Deemed admissibility of complaint post 21 days of application. So if I apply what tribunal generally does, it is not just because I have applied, saying that, okay, I went to doctor so-and-so, he treated me for such and such an ailment. Somehow I feel he is being negligent because I'm not cured properly. It is not necessary for the forum or the consumer court to immediately put the other party or opponent to notice. They will do what is called as a preliminary verification. So what is this preliminary verification? They try to prima facie look into the complaint and see whether it is worth taking. But today they have a provision which says, when I complain and lodge my complaint, if they don't really say anything till 21 days, it is deemed that my application is accepted. This deemed, admissibility is also going to be a game-changing rule. And most convenient forum provision. Sue at your hometown, and 34(2)(d) says, opportunity to file complaint at the place where the complainant resides or personally works for gain. Earlier, it was at the place where the doctor is residing or doctor is performing, etc. But today, I can go to Jaipur, get my treatment, and come back to my hometown, maybe Bangalore, or right now I'm speaking to you from Hubli, that is my hometown, I can come back. And somehow I'm not happy the way I have been treated. I can go to the local consumer so-called commission or forum and litigate against the doctor, and the doctor had to come here and defend himself. So these are a few of the points which I thought I would just try to highlight. See, I was referring to Central Consumer Protection Authority. This is a brand new authority that has been established. It is an executive body which will look into predominantly misleading advertisements and unfair trade practices. From July, with effect from July 24, 2020, the Central Consumer Protection Authority is established. And the law says to regulate matters relating to violation of rights of consumers, unfair trade practices, and false or misleading advertisements, which are prejudicial to the interest of the public and consumers, and to promote, protect, and enforce the rights of consumers as a class. Right. What I'm trying to really say, without dragging you into the minute details, I wanted to leave you with two very important points. The first point, ladies and gentlemen, is that how this Central Consumer Protection Authority is going to unleash its activity, how it is going to impact. We have to wait and see, because it is too early for us to come to any conclusion right now. But the second point, notwithstanding what I have said so far, or without prejudice to my first point, I wanted to tell you there are two areas, if not more. Number one, advertisement. See, doctors cannot advertise, but hospitals do advertise. Establishments do advertise. So when that advertisements, when they come, the Central Consumer Protection Authority is likely to impact. This is one area. The second one, the most prevalent practice or most prevalent part of present day practice is what you call as package treatment. So when I have a particular ailment, you generally try to say this is a package. If I pay that much of money, you would treat me end to end. Or at least you would say I would be treated end to end with some fine prints, which I would come to know only when doctors demand for more money. With due respect, I am saying, just to communicate, I am saying, so these package deals are going to come definitely under the scrutiny of Consumer Protection Authority, and they are likely to, take note of that. So this is one more very important area which you need to look into. So what is the way ahead? Although I have not been asked to talk about way ahead, but I personally think I would spend a couple of minutes and try to, say few things, whatever I feel, and I try to be as candid I can. First one, can we afford to avert law any further? I still see there are a lot of doctor friends who are trying to find out ways and means by interpretation, by technicalities, wriggle out of this particular law. Is there any way? I would say, unless these two things happen, one is you again challenge it in the Supreme Court and challenge the validity in the changed circumstances of VP Shanta and say, look, let the law be set right. At that point, if Supreme Court says, okay, I will change the ratio of VP Shanta or my stand as I took in VP Shanta, and I would now say, let doctors or any other professions do not get covered under Consumer Protection Act. You cannot avert the law. That is point number one. The second one is many doctors who argue saying that Ram Vilas Paswan did say like that, and they construe to say that they are eliminated, etc. I always say, if that were to be true, the very statute clearly has a provision. It contains a provision which says, if central government wants a certain, services to be kept out of the ambit of Consumer Protection Act, they can notify so. So you get the notification from the central government. Once the central government notifies, saying that health services or doctors are kept out of the ambit of Consumer Protection Act, this law will not be applicable. But till that time, unfortunately, I am afraid you cannot be averse to this. Number two, the roots of litigation against a doctor is due to loss of trust and changed face of doctor-patient relationship. You talk about trust deficit. See where from this trust deficit comes from. Believe me, you ladies and gentlemen, since last 18 years, I'm working in this particular area, namely health law, or I'm working in the area of health law. Doctors have considerably lost their autonomy to commercial forces or market forces. And because of that, today, you people are finding yourself so helpless. It is not the law, it is much bigger sort of a conspiracy which you needed to decode. And restoration of trust into doctor-patient relationship and better education to medical professionals. Many doctors, I find, are extremely afraid of law. It is not because of anything. If not 100%, majority or 2/3 of it is because they don't know what law is. They do not know what happens if they are taken to, consumer court. The moment they receive a lawyer's notice, they actually start calling me. Believe me, every now and then I hear from the doctors. They call me frenetically and say, sir, I have got a lawyer's notice, right? And now I wanted to take some kind of what do you call as anticipatory bail. I say, look here, it is only a civil litigation. There is no need for you to take. So what I'm trying to say, ladies and gentlemen, many of the doctors don't even know the fundamentals or rudimentals of law. So the time has come, you need to know a bit of law as well. So knowing law will actually help you assess your own situation. And once you know about your situation, you would not be that afraid regarding that particular law. So I have no more to say than this. Before I hand over the baton to the doctor who introduced me, I just would like to place on record my sincere thanks to all, especially the doctors in NIMHANS, for providing me this opportunity and forum to share few of my thoughts. Thank you very much.
Thank you, sir. That was really fascinating and timely coming from an expert in the field of health laws. The knowledge you shared will help us immensely in becoming more responsible psychiatrists and has definitely ignited interest in many of us to go back and read about the Consumer Protection Act. Thank you again, sir. Now I request the participants to unmute themselves and ask questions, as Professor Omprakash sir has to, Nandimat sir has to leave for another function. Please unmute yourself.
Prakyat, any questions are there? You can read it from, even for Dr. Shekhar Shadri is there. So
I request the participants to ask questions to Dr.
Prakyat, there's a question for Dr. Nandimat on chat.
Yes, sir, yeah.
from Dr. Alok Jyoti. Let me read it out for Dr. Alok Jyoti Sahu asks, at times patients or family members try to take undue advantage for their own hidden bona fide interests, and how do we approach this in the context of consumer protection?
Sir, thank you, Dr. Sheshadri. Thank you very much for reading that question out to me. My answer is very crypt and simple. Somehow, emotionally, we trying to really establish, yes, when we are talking about legal recourse, we are trying to open the door as wide as possible for the consumer. That is why I started by saying the whole idea and ideology behind consumer protection law, or the second version of consumer protection law, so to say, is to do consumer welfare. Here, nobody is looking from the point of view of the doctor, nor they are looking it from the point of view of service provider, how it is going to cut corners, how it is going to make somebody bleed, etc. So our whole focus is upon the consumer welfare. So your argument saying that, oh, it is unfair to the doctors, or doctors are taken for a ride, or doctors are the worst hit by this kind of an approach, etc. These are very generic lamentations. And you cannot really with that try to find out some kind of a solace or solution to this. Don't take it as a reply, but this is what I wanted to add and caution you. Sir.
I have seen Alokik's question pertaining to me, but since Professor Nandimat has to go, perhaps he can take Krishna Vasan's question also. Will government doctors who deliver treatment by free come under the purview of CPA 2019?
It's a good question, sir. Thank you very much for asking that. Anything which is provided free of service is exempted from the purview of Consumer Protection Act. But it is not that simple as I have made it appear. Take the example of NIMHANS, or take the example of Jaideva, where you have a hybrid method. I call it as a hybrid method. You may be calling it by different. What I mean by that is you have two streams. That is, one stream, you treat people completely free of cost. On the other stream, you charge them either moderately or full-fledgedly, depending upon his capacity to pay. And for that, you have something called as above poverty line and below poverty line type of a classifications and things like that. And if you look at the entire structure, at that time, you collect money from those who can provide you or give you money because of their economic ability. and you try to subsidize the treatment for some, and you try to provide treatment free of cost to somebody else. At that time, law is very clear. When VP Shanta was decided by the Supreme Court, they said, when you have this kind of a cross-subsidized model, you are charging some and you are not charging some. At that time, the entire hospital establishment gets covered under Consumer Protection Act. So rather than approaching it from government to doctor, I would say, suppose if you are a government doctor treating patients in PSUs, primary health center, or PHCs, that is primary health centers. At that time, you do get, you're not covered because you are not charging anything. But if you go to the district hospital where you are charging, you have the policy of charging, then you get covered. You go to super specialty hospitals, the entire establishment gets covered. This is how we needed to really look at.
Thank you very much. Very quickly to address Alokik's question. The first thing, Alokik, I want to say, and I know why Suresh is smiling, because I've been repeatedly discussing this with Bhavika. Friends, the term transgender is not a noun. It is an adjective. There is no such thing as transgenders. It is transgendered person or transgender people. It is an adjective, not a noun. But this is something that we need to constantly iterate in our minds till we get the semantics right. Coming to the specific question here, there are several things that are happening. One is the issue in very many forms of, a male, female, and third gender. That's how they fill it. But let's go back to the point that we made about self-identification or self-determination. So if a male born who's transgendered is basically a woman, and she identifies herself as a woman, and so if a transgendered person who's female, who's male born, is a woman, so and she tells you that put female in because that's who she is. Or if the person is male born and has a trans identity, that person is male. So that's what you put down. But the issue is a little tricky, in the sense of the purpose of, if you look back to the comment that I made about the Nalsa student who said, put the term MX in front of men, because I do not subscribe to the binary, I'm non-binary and I don't wish to. So it really depends on for what purpose the document is used, especially in the light of the Nalsar Supreme Court of Union of India judgment on issue of reservations and so on, that there is a certain reservation if your name is put in the category of transgendered or in the third gender category. So you have to look at it within that framework and make the decision. Over to you, Prakhyath.
Thank you, sir. I thank Professor Nandimat sir and Professor Seshadri sir for clarifying the doubts of the audience. Thank you again, sir. Now, I would like to invite our next speaker, Professor Suresh Badamat sir. Sir has completed his MBBS from KIMS Hubli and MD in Psychiatry from NIMHAS, Bengaluru. He has continued his academic career and earned various degrees such as DNB in Psychiatry, Postgraduate Diploma in Medical Ethics and Law, and Postgraduate Diploma in Human Rights and Law from National Law School of India, University, Bengaluru. He also did a PhD in Law from National Law School of India, University, Bengaluru, and is currently the Professor of Psychiatry, Head of Forensic Psychiatry Unit, and Head of Telemedicine Center at NIMHAS. Sir, hereby I request you to speak on challenges and opportunities in implementation of Mental Health Care Act 2017. Over to you, sir.
Thank you, Dr. Prakhyath, and I also thank all my teachers who were there. Basically, our director, Professor Pratima Murthy, Dr. Shekhar Seshadri, and Professor Nandimat sir, because they are the giants. On their shoulder I'm standing. Without them, I'm nothing. So thanking all my teachers, I would like to step forward to discuss about the opportunities and challenges with regard to Mental Health Care Act. See, behind every opportunity, there will be an opportunity hides behind every challenge. For example, COVID. COVID is a big challenge. Now, this is the time we can revamp the mental health care. whenever there is a disaster, there is an opportunity to rebuild. The best example I can give you is in 2013, Dr. Naveen, myself, and our team worked in Uttarakhand. We went as volunteers for the disaster work. There we found that mental health, DMHP, district mental health program, was not there. So we proposed telling that there is no DMHP, district mental health program, and we need to implement. Immediately, the central government took it up seriously and it started running within a matter of 1 or 2 years. That means whenever there is a challenge, please search for an opportunity. There will be a massive opportunity. So as soon as you see the challenge, don't run away, because if you move away, you will lose that opportunity to change something. So Mental Health Care Act is a challenge. And there is a huge opportunity, not only for all stakeholders, to even to the psychiatrist. If you look at the mental health care law, there has been a paradigm shift which are occurring. One is Lunacy Act, where it was more of custodial in nature. Before 1905, it was under the prison department. And in 1905, it was handed over to health department in India. So hardly 110 to 115 years back, the health department received it. And in 1987, the treatment of persons with mental illness came into picture. The treatment was given more importance rather than the rights. It was not more of custodial. Now, in 2017, it's not the custodial care. More than that, the protection of human rights of persons with mental illness during the provision of services. That's where the important paradigm shift occurs. You're not only providing treatment, you need to uphold the dignity and also human rights of a persons with mental illness. So here there is a challenge. You have to protect their rights, but also to provide treatment. So that's where the issue comes here. And in the Constitution of India, under that, the first legislation which enumerated the rights of a persons with mental illness or any patient. This is the first time. That means the legislation says this is the rights of the patients. That has been first time has been enumerated in this law. That means the rights have been enumerated. The rights do not come with what we call it as it can be given, but at the same time, it is not just given, it is entitled. It is by birth they are entitled. That is the way it has been envisioned. So if you look at this, the very important crux, Section 18, this is one of the heart and soul of this whole legislation, which says right to access for mental health care. That means the state has a responsibility to provide care. The provision of care is both inpatient, outpatient, rehabilitation, and it should be affordable cost, quality, and quantity. And if you don't provide, that means if the patient do not get mental health care, they can go to the Mental Health Review Board and can give a complaint. If the MHRB is not there, they can approach the High Court and say, sir, in my district, mental health care is not available. These are this IP, OP, or rehabilitation. And you need, since they are not providing, and this is my right. And the legislation is very clear. And then the government has to provide compensation for taking treatment somewhere else. That has been clearly spelled out. That means the first health legislation which talks about compensatory mechanism, though there is a challenge of providing rights, but at the same time, the first health law which talks about the provision of compensation, not only that, making the government itself accountable for providing services. And also says free treatment for BPL and destitutes and long-term care to be included here. That's the way the law has been envisioned. That means there is an opportunity, there is a challenge, but there is an opportunity. So government now should make rules to reimburse the cost if the treatment is not available. And clearly it has been said that they have to provide. Already one of the case law which has been already dealt, and I think in Uttar Pradesh, there is a compensation has been given to the persons with mental illness for not providing the services in the state. That means now the state government has to provide services, which I spoke, in all districts. There is a challenge, but an amazing opportunity to improve the mental health services in our country. At the same time, it also enumerated various rights, like right to protection from cruel, inhuman, degrading treatment. These need not be told, but unfortunately, these do happen in mental hospitals. just 10 to 15 years back, these mental asylums, so-called, I should not use those words, asylum, but unfortunately, they do exist in our medical literature, legal literature, even the court rulings talk about those words. Unfortunately, those hospitals continue to be worse than the prisons. Imagine, these are the patients who have not done anything wrong, but they have got illness. But their condition of living is inhuman than the prison, imagine. So in such a scenario, these are the rights which have been enumerated. That means safe and hygienic environment, adequate sanitary conditioning. Just 3 years back, NIMHANS was involved along with Professor Pratima Murthy, our director, and Professor Prabhachandra. We did a study across Indian by randomly choosing some of the hospitals and did ask for the way women are treated in mental hospitals. Just sanitary napkins were not provided in most of the hospitals. And the so-called privacy was very less in those places. So clothing was a big issue. And majority of them, they said, sir, we don't even get powder or even kumkum. So these which we may call it as, what is this? You're talking about cosmetics. But invariably, these are also patients. They also would like to be dressed up. So these simple things which can be done was ignored. At the same time, many hospitals were providing rehabilitation services, and some of them were made to go for the rehabilitation services. Now in this law, it says if you are getting rehabilitation services, you may have to provide remunerations for that. And also you should allow them to wear personal clothes. You cannot say that this is the uniform which we are going to give you and you have to take. Unless the person doesn't have any cloth, you may give the hospital which it provides. But if the patient says that I want to bring my own clothes, you have to allow them to bring it. And earlier there was a ritual that any patient who gets admitted, there used to be tonsuring used to occur. But now that is not to be done unless there is a medical indication, and avoiding all kinds of abuse. Now the challenge is the resources. Of course, the resources means to provide all these things, the state government or the central government need to provide resources and opportunity to make these hospitals safe place for our patients. At the same time, we talk about right to equality and non-discrimination in this legislation. That means it has to be seen equally with the physical illness. That means if you are providing a budget for physical illness, a similar budget should be given to the mental illness. That's how it has been put across. That means if you are providing emergency services for physical illness, that means emergency services also should be provided to the mental illness. That's the biggest challenge is resources. But now, if you don't provide emergency services, the patient and the patient family can go to court and say, here, this is provided and this is not provided. In this background, which was again discussed in the Karnataka State Mental Authority, immediately all the ambulance services were trained in taking the patients, that is persons with mental illness, and till date, no persons with mental illness is refused for ferrying them to the hospitals. So these kinds of right to equality and non-discrimination played a very crucial role. Coming to the insurance. If you see earlier, around just 5 years back, the mental illness was an exclusion clause for getting the health insurance. But now it is very clear. They cannot exclude for persons with mental illness telling that you are mentally ill, we will not give health insurance. That is not allowed. However, slowly, many of the insurance companies started adding mental illness for their health insurance. Of course, the premium has slightly increased, but there are clearly, even including government, Ayushman Bharat has clearly taken all the mental illness under their ambit. So it is in the pilot mode where the government hospitals are providing over a period of time, it will be rolled out to the private hospital who are enrolled under Ayushman Bharat. So the opportunity is huge. That means insurance for persons with mental illness cannot be denied. That is how the opportunity is there. Coming to equality for like I mentioned already, the resources provided for physical illness there, that means the same amount of equal or maybe the proportionate amount of budget should be given, which has been denied, but it's not far. There are persons with mental illness and their family members will go to the court, say this is written in the legislation. The legislation is passed by the parliament and they are not adhering to it. That means already, if you look at in Supreme Court, there are cases for not implementing Mental Health Care Act. There are cases in the high courts for not implementing Mental Health Care Act. So there is a challenge, but also an opportunity to provide services. So that's how I would like to put across. Coming to the duty of right to confidentiality. Today, again, one of the person who had mental illness and he got COVID. And immediately when he was diagnosed as COVID, he attempted suicide, and unfortunately, there was a death by suicide. The family members came to the hospital, Niman's hospital, after almost 6 months down the line. They said, please close the file. The reason was they are apprehensive. Already that person has expired. Why should the file be here? This was the question. That means, please destroy the file. That is the way they put across. So right to confidentiality is now very clear. That now today I had spent around 10 to 15 minutes along with the other team members who also sat with the family members, explained the right to confidentiality. And this is how the confidentiality looks. And this is what the law says. At this point of time, we may not be able to destroy the file. So we have to tell them, and then said, we are keeping it highly confidential, and most of the patients who are there, file is there, only the persons with mental illness can access the file, nobody else. And that too has to give in a proper forums, and that will be honored. And they are entitled for right to basic medical records. If the psychiatrist has a doubt of giving the records, he can approach MHRB to guide him whether to give or not to give, and the whole responsibility will be on the MHRB. That is how the law has been written. Here, Mental Health Review Board, if you look at it as a challenge, it is going to challenge my practice. I would rather consider it as it is an opportunity to liaison with the review board wherever you are confused or you are in a gray area. Ask the Mental Health Review Board, they will help you out. Of course, the next question you may ask is, sir, there are many states, the Mental Health Review Board is not there. Of course, the COVID has come in the way, and slowly the Mental Health Review Boards are getting formed. At least 4 or 5 states have already notified in the newspaper for hiring the Mental Health Review Board members. And in another 1 or 2 months down the line, there will be a national level seminar regarding the state mental health authority and rules. That will be done. So coming to again the Mental Health Review Board. So I said that it is a quasi-judicial body. The challenge is providing human resources for that. Simple human resources means, do we have so many judges or retired judges? Can we provide money to them? Can we provide a vehicle, place? And MHRB sometimes, since they already worked in the court many years, it can become adversarial procedure where the lawyer will come, the opposite lawyer will come, and they argue, and the case goes on. Will it be delayed? That's the challenge. It may happen. There is a possibility, I'm not telling. But however, I would look at the opportunity side. Opportunity is liaising with Mental Health Review Board, and in gray areas, asking for their opinion. Before the patient goes there, you may also approach the court for help. The other essential paradigm shift has occurred with regard to decriminalizing suicide. That is, Section 115 clearly says whoever has attempted suicide will be considered because of stress, and they cannot be charged under Section 309 IPC. That is by default. But however, if the police is able to prove it is nothing to do with the stress, he's trying to manipulate here. That means he can be still charged under 309 IPC. That means 309 IPC has not been completely removed. But there is a clause which has been put across telling that because of stress, you cannot punish him. But however, the police, if they are able to prove, they can go ahead. But however, you have to focus not on 115.1. Most of us are discussing about 115 subsection 1. But the important is Section 115 subsection 2. Here, clearly, the legislation says the government shall have a duty to provide care, treatment, and rehabilitation whoever has attempted suicide, so that it will not repeat. See, here is an opportunity again. The opportunity is a person has attempted suicide. Now the government has a responsibility. Imagine if in India, every year 139,123 people death by suicide is seen. Into 20 is the number of attempts. That is around 27 to 28 lakh people attempt. This is as per the available NCRB data, and extrapolating into 20 by the WHO what it says. This is the number. In this 28 lakh people who have attempted, some of them will be seriously, if they have taken OP poisoning, if they have tried to jump from a second floor or third floor, they require care. Already they have a poverty or other issues. Along with that, now they are hospitalized for the treatment. Now this legislation says the government has a responsibility now to provide care and treat and rehabilitation so that it doesn't recur. So I would rather focus more on 115.2. Of course, 115.1 is good, but 2 is the best. So that is how I would put it across as an opportunity. Now coming to some important clause which we usually don't read in this Mental Health Care Act. First and the foremost is 105. Section 105 says, if during any judicial process, before any competent authority or the court, proof of mental illness is produced and the opposite party or the same party says that he is mentally ill and the opposite party says that no, it is not mental illness, it is challenged. So the court will refer to the Mental Health Review Board. Mental Health Review Board, as you know, consisted of 6 people. They may examine the person and give opinion, or else they may ask the expert committee to give an opinion with regard to 105. That means if I have seen a patient as a psychiatrist and after 6 months or 1 year down the line, the husband would have approached the court telling that my wife is suffering from mental illness. The wife says, I'm not so ill and he is unnecessarily pestering me. Then the court may not ask the psychiatrist. Now, as per section 105, it will ask the Mental Health Review Board to give opinion about this case. So, and even MHRB can ask for the expert committee. They can form a committee and the committee will give the opinion to the court. So the responsibility of the psychiatrist, individual psychiatrist, in the court of law will reduce. So the number of litigation against psychiatrists will come down. So this 105 is one of the rescue clause for psychiatrists. Coming to 106. This is again, I would rather no mental health professional or medical practitioner will discharge any duty or perform any function not authorized by the Act or specify or recommend any medicine or treatment not authorized by the field of his profession. This is a contentious issue, but Indian Psychiatric Society and many psychiatrists, our fraternity or my colleagues will be very happy to learn and see here that psychotropic medication cannot be given by any others, only psychiatrist will give, because the last word clearly says that not authorized by the field of his or her profession. So this is another 106 section or the clause which is very beautifully drafted. Moving to 116. Here again, one of the best clause I would rather say in the whole the legislation, no civil court shall have a jurisdiction to entertain any proceedings in respect of any matter with the authority or the board is empowered by or under the Act to determine, or injunction shall be granted by any other court or the authority in respect of action taken by the pursuance of the power conferred under this Act. That means if any issues, it may be rights violation, it may be with regard to providing the quality of care is less. That may be even including the doctor or the psychiatrist has not provided the care and he has not attained the standard of care, that we call it as malpractice. Even if this is challenged, and Mental Health Care Act will be taking rather than the Consumer Court. This is how I would like to interpret. But however, if the patient would directly go to the Consumer Court, that is a different matter. But here, it clearly says no civil court shall have a jurisdiction, only civil court. If it is a criminal case, it will definitely IPC, Indian Penal Code will prevail. But here, no civil court cases. It may be including consumer court, or it may be including the human rights violation of against persons with mental illness. The Mental Health Review Board will have jurisdiction over such case. But however, this is a which needs to be taken. Somebody has to challenge it in the Supreme Court and say, no, all these cases will come under the ambit of Mental Health Review Board. Then we need not go to many other cases, many other boards for fighting the cases. That means they have to go through Mental Health Review Board first, then the other ambits will be coming into picture. Coming to the last part of my presentation with regard to challenging the clause. That means challenging clause are which will challenge the psychiatrist and the fraternity and also to the family members. Here, it revolves around one important concept of Mental Health Care Act is capacity to consent for treatment or maybe admission. it clearly, basically the whole capacity revolves around three things. One is the comprehension, weighing the risk, and communicating. If you look at the comprehension, but the issue here is or has been placed. That means if the person is able to comprehend, that is itself is fine. Or if he's able to weigh the risk, or is able to communicate the decision, I don't want treatment, that means he has capacity. This is how the law has been written. That means if you take the word by word and you interpret the law, just the patient says, I don't want treatment, means he has capacity. Yes, there is an issue in this. It needs to be discussed and may have to be amended. But however, the assessment guideline has modified, but however, assessment guideline is just a guideline. Here is the legislation I'm talking about, clause 4 of the Mental Health Care Act. This is a contentious issue. I don't have answer regarding this, but however, capacity assessment is very clear. And that capacity assessment talks about where are the condition. And again, it has been brought by the Mental Health Care Act where the assessment has to be done, under what circumstances, during admission, during treatment, when providing information, or it may be providing the medical records, those capacity assessment has to be done, or even during the discharge. So those are the places where capacity assessment is to be done. So the consent becomes valid. So again, one more issue is advance directives and nominated representative. Advance directive is, again, the patient can name anybody, telling that they will decide about my treatment, or else he or she also can say, I would like to take treatment in certain place. Maybe I would like to take treatment with this. Like advance directive is basically a living will which says that how I should be treated or how I should not be treated. And if I have to be treated in certain way, this is again a big issue with regard to some of the places where if the person writes, I have to be treated. Suppose imagine a person who is working maybe in the paramilitary, military, or Air Force or anywhere, and he has developed the illness and he has written an advance directive that I have to be treated only in Nimans, nowhere else. That means advance directive has to be upheld. Now, the period taken from there to coming here will be a huge time. What will happen during that period? Only 72 hours has been given under Section 94 for emergency treatment. What will happen? This is a challenge. Definitely, it will be a big challenge in front of the various authorities. How it will be dealt, it will be definitely maybe requiring an amendment or something else which has to be discussed. Again, nominated representative, patient can write anybody's name. He may write Mr. X and he may just drop the family member's name. It may happen. It definitely, those cases will go. And of course, Mental Health Review Board is the board which can override these advance directives or nominated representative. Coming to the role of family, of course, the Mental Health Care Act is an act which gives complete autonomy to the persons with mental illness. At the same time, the role of family members have been completely denuded, or what we call it as they have completely taken off. Family plays a crucial role in India. If you take more than 13 crore population who are suffering from mental illness, it is the family who provides care. If you look at the number of beds in the whole mental hospitals, especially in India, they may not cross more than 35 to 40,000. I'm talking about government, including medical colleges and district hospitals. If they are providing inpatient cares, it will not cross more than 50,000. But we have 0.8% severely mentally ill. That means around 80 lakh to 90 lakh patients with severe mental illness. With remaining 10%, it will cross around 13 crore. It is the family members who are providing care. Wish our legislation would have given more power to family members. But again, this is again a contentious issue. As a professional, we may not be able to do anything. It is the family members or the association for the family members need to fight for their whatever their rights are there. It is one hand collective rights versus the individual rights. That's how it will be taken into consideration. But however, human rights is highly individualized, that may say, but however, in a country where the collective rights prevail over the individual rights, then the issue can be discussed. But if tomorrow Indian state governments and Indian central government are able to provide huge amount of budget to mental health, then of course advance directives will prevail, because if the patient says, I don't want them, and the parents also have a right to say, I don't want this person, let the state government take care of him, and the state government has to provide care because it is a rights. Advance directive has written. So he says that I have to be provided care in a big hospital, maybe an Apollo hospital or some other hospital, or maybe Columbia or somewhere else. And that money cannot be afforded by the family member. Now the government has to provide. That's how it will be written, or how it will be interpreted, because he has a right to make advance directives. Otherwise, it has to be challenged in the Mental Health Review Board, and the review board has the right to nullify the advance directive. So this is how it may consider. But at the same time, we have to consider two different things. One is rights enabling legislation. Another one is rights protecting legislation. That means if the person has developed mental illness, but he has not lost his capacity, he is almost in the verge of losing, but still has capacity. Should we wait for him to lose capacity and then treat? Or else he has already developed mental illness and he is refusing treatment to enable to get his complete rights so that we will treat. So a balancing act has to be done. This is a very a issue which needs to be discussed, because some countries fall on the ambit of telling that whatever may come, we would like to provide rights as it is written in the law. Some of the countries says that yes, he had mental illness, now he is developing mental illness, but he has not lost the capacity. He may refuse treatment, but Mental Health Review Board can ask him to take treatment on outpatient basis. That means you will not force him for treatment, but you will enable for the family to provide treatment. So how this review boards, how our courts will interpret makes a big change. But however, we have a role to educate Mental Health Review Board to tell them the family are the first comers. They are the people who are taking care of our patients. Not me being in NIMHANS will be able to provide. I can provide hardly few numbers, very milli fractions of numbers, but the huge number is in the community. And we have to provide care in the community, and we have to enable the family to provide care. Even I would rather even ask even the government to provide some kind of pension for providing care for a person with mental illness. Imagine if there is a severely mentally ill patient is there, looking after him is a full-time job. It's not a part-time. It's a full-time job. The family members have to fight. They have to provide medicine in spite of that person has illness, behaving abnormally. They have to be cool, calm, provide care, and take care of him. Coming to the very important concept, last few slides, there is something called as Penrose Law. Penrose clearly said that the population of the prison is inversely proportional to the psychiatric hospital population. Imagine if you start refusing all of admission to the patients inside the hospital who require admission, they will enter into conflict with law and they will be arrested. That means more and more people you're going to see in the prison. Because if you treat them early, conflict with law will reduce. That means they will not be arrested. If you don't treat them and you say, so his capacity is preserved, I will not treat him, but the family is requesting for your treatment, but you say, no, capacity is there, then he will, majority of them may not do, but someday or the other day, because of his illness, he may assault his family members. Family members may throw him out of the house, or family members themselves may give a complaint. In such a scenario, the prison population with mental illness will increase. That was observed in 1939, not very far. Before deinstitutionalization, it was discussed at that time. At the same time, there are a couple of laws which I would like to bring in: Bryan's law and Kendra's law, Laura's law. These are all in the developed countries which talk about community treatment order. Here, a person who has mental illness, who had repeated relapses, severe mental illness, they have put the criteria. Those patients need to be on medicine. That time, the Mental Health Review Board or the judiciary gives an order that he needs to be on treatment. In such a scenario, the court and the judiciary, along with the police or the other law enforcement agency, will make sure that he takes treatment. However, this is debatable. No, we should not bring in. But I would rather say, I will ask the family members. If the family member says, sir, I'm finding it difficult to provide care, I require help, I would go with the family. then I would like to enable the family to provide care. Coming to the, how do I will fit in this in our Mental Health Care Act? Yes, in Mental Health Care Act, leave of absence, Section 91 clearly says that if you are, before you discharge somebody from the hospital, you can put certain conditions. It is basically not discharge, it is a leave of absence. You can place certain conditions telling that till that day, you need to take treatment, otherwise you will be brought back to the hospital. So that condition can be brought under Section 91 and CTO can be placed here. That is community treatment order. Again, these orders can change from one state to another state. And also, it can be a uniform across the nation. But high time, the family members need to, because now we are seeing again in the pandemic, we are seeing severely ill patients are coming. And it is when the patients are severely ill, it is easy to treat. It is when the gray area, the person has insight or the person has capacity and is refusing treatment. That is the duration where you fall into that gray zone, what to do. So such situation, you may have to take the help of the MHRB, and even the NHRC, National Human Rights Commission Advisory 2.0 that was released on 31st May 2021 also says that MHRB has to be formed across all states. Coming to the last slide, the Mental Health Care Act is rights-based. Of course, it is challenging for many psychiatrists, but it has brought in a huge responsibilities at the same time and opportunities. I would rather argue for the collective rights for the family members. Certain definitions need to be refined. Capacity consent needs to be amended or has to be removed and has to be brought in. And because it is a comprehensive phenomenon, it is not an individual A, B, C. And we need to work with the Mental Health Review Board. And also, if the Mental Health Care Act is not introduced or implemented with the spirit, but as only law if you are introducing, then the cost of mental health care will increase phenomenally because it is going to cost the patient or the state. So that will be a big problem. But however, there is a role or a scope for discussion for compulsory community treatment order, and it needs to be asked by the family, not by the doctor or by the psychiatrist. It has to be asking from the family members, like wife says that my husband has this problem, and then the opinion of the Mental Health Review Board, and the C2 has to be done by the independent judicial body, that is Mental Health Review Board, not by the psychiatrist. Psychiatrist will watch, telling that yes, he has illness or not. That can be one of the point of discussion which can be taken up. To summarize, though Mental Health Care Act 2000 has taken a massive step in the right direction, but this rights-based approach comes with huge commitment from the state, and also huge resources has to be provided. Not only resources in terms of money, but also to the manpower. That means now the obligation is both on the central government and the state government. Already many PILs have been placed in the High Court and Supreme Court. That means there is a challenge, but also an opportunity. Please look at the opportunity. Thank you very much. And all these videos, whatever is there, it is available on YouTube. You can find those videos there. Thank you very much. Over to you, Dr. Prakyat.
Thank you, sir, for sharing with your expertise and insight. We really enjoyed it. Now, I ask the participant to put the question in the chat box. There is one question already by Dr. Alok Jyoti Sahu. The question is, in District Mental Health Care Review Board, so many paperworks, documentations, calling the meeting to order, visiting the mental health services, and so on, but no office assistant to deal all three large and challenging chapters in future days. How to approach this issue?
Yeah, see, the Mental Health Review Board talks about the requirement for 6 people. That is mandatory. You can increase the number. 6 number is as per the statute, but you want office assistant boy, you want a driver. You have to bargain with the state government to increase the number of people, office assistant, computer operator, all those things. It is left to the state. The state government can increase the number. Even the state mental authority, they have given the officios and ex officios. Ex officios have been given, non-ex officios have been given. But all other supporting staff has to be there if the government is able to give. That's what I was telling you, that the huge amount is required for implementation of this legislation. Of course, it's a big challenge, but it's an opportunity to increase the budget for mental health care. I would rather look at it, oh, there is no money. No, I would rather say, this is the legislation which says that increase the budget. So it is now earlier it was just asking budget. Now there is a legislation which talks about it. Use that legislation to increase the mental health care budget. So of course, the law will not write there will be a security guard, there will be a clerk, there will be a driver. It will not be there. That is left to the state authority or the mental health review board to have as many number supporting staff. It can be permanent or it can be maybe part-time, it can be contract basis. Depending upon the requirement, it can increase or decrease. But the mandatory is 6 MHRB members as per the statute. Over to you, Dr. Prakyat.
Thank you, sir. There are no more questions.
Dr. Naveen wants to say something.
Yeah, can I, Prakyat?
Sure, sir.
Yeah, just to add on to what Professor Suresh said. See, it's a new act and it will take time. We need to be a little patient is what I feel, because when compared to the Mental Health Act of 1987, I mean, many seniors are there in the audience, so they all will be witness mental health, state mental health authorities were themselves not formed even after 20 years of forming the act. But now, I think there is a lot of push and mental health authorities are being formed. Governments are waking up to the new realities, new obligations. As is written in the act, they can't, go anywhere but to, invest in mental health. But as the current scenario, the health budget itself is grossly, experts say that it's very deficient, and the mental health is even more less. But I'm sure things will change one after the other. I think we need to be, a little patient. And as regards the review board thing, yes, it will come, but it will take some time, is what I feel. That is what I wanted to comment. Prakyat, please.
If someone want to ask question, they can raise their hands.
There is a question to Professor Shekhar Sheshadri, sir. Sir, there is a question. No, sir, it is your comment only, sorry. On POXO Act.
No, that's my comment to essentially to the rider that Alokik made, that he was asking about a legal aspect of what gender to put down, because in an instance of sexual assault, because gender becomes an issue, to which I said that gender-based violence has its own framework, but a sexual assault is a sexual assault, irrespective of whether man-woman perpetrates it on man-woman. So the legal perspective is the nature of the act that is considered. But gender, of course, nuances the mental health impact. And this is an instance, Suresh, I came across recently. The police refused to lodge an FIR saying, no, women perpetrators cannot be, an FIR cannot be lodged on the basis of women perpetrators. So we found this very strange, yeah.
Yeah, definitely, sir, because even the definition of rape has changed now. Definitely, even over a period of time, even this clause of rape will come out, and then the penetrative, non-penetrative sexual assault will be there. The way the POXO has been put across, it's an amazing law. There, again, though there are shortcomings, but one of the best at this point of time. So that law talks about gender neutral with regard to children's sexual offense. It's not far, maybe in another 10, 15 years, we may have gender neutral rape laws. So that's not far to come there. And I definitely thank Professor Shekhar Sheshadri, sir, and also Dr. Nandimat, sir, and Professor Pratima Murthy to guiding us to bring this forensic psychiatry along with me, Professor Naveen, Dr. Guru Gowda, Dr. Sedni. They are all working with us with regard to build a good forensic psychiatry team and also to good training center at NIMANS. Over to you, Dr. Prakyat.
Thank you, sir. There are no more questions. I request Dr. C. Naveen Kumar, sir, Professor of Psychiatry, Head of Community Psychiatry and Consultant in Forensic Psychiatry Services, NIMANS, Bangalore, to deliver the vote of thanks.
Thanks, Prakyat. I think it's my pleasure on behalf of the Forensic Psychiatry team to propose a vote of thanks for this wonderful program. And many people are responsible for this, starting from the NIMANS administration, our director, our HOD, and the whole forensic psychiatry team, and the telemedicine team, of course, our distinguished speakers, Professor Pratima Murthy herself, and Dr. Nandimat, Dr. Shekhar P. Sheshadri, and Dr. Suresh Badamat, and not last but not the least, the distinguished delegates, and also the med scientist people who helped us in formatting and typesetting these things, and all the others who I may have missed. So thanks one and all for making this CME and program a success. Wish and hope we come across many more such CMEs in the future. So thank you one and all, and of course our IT cell, Chandru is sitting here, and without his help, the IT cell, the data center, the BME of NIMHANS, and many more I may have, I would have definitely missed. So apologies to that, and thanks a lot. Thanks everyone. Thank you.